We now get to everyone's favorite, not so much part of a human rights or international law course, namely the topic of reservations. It's a very technical subject and it is not necessarily always all that relevant in the kinds of assignments or questions that you will be researching. But I do want to encourage you to spend some time on this video, because if you understand reservations, if you understand how they work in international on the one hand and in human rights law on the other hand, you've really understood the way in which these legal frameworks operate. So what then, to start with, is a reservation? And for most of you, this will be simply a reminder. Let me read out the definition given in the Vienna Convention on the Law of Treaties in Article 2D, which is that a reservation is a unilateral statement made by a state when signing, ratifying, accepting, approving, or acceding to a treaty, whereby it purports to exclude or to modify the legal effect of certain provisions of the treaty in their application to that state. Put in more accessible language perhaps, a reservation is basically a state having the opportunity to say, well, I agree to a treaty except for this provision, meaning that this particular provision also will not have any legal effect, but that all the others will have. Now, often the question among students is, why do we have such a thing in the first place? Why do we have reservations? It just complicates matters. Well, the obvious answer here is, it's because of the consent-based system. So if you have on the one hand the option for states to ratify an instrument, a treaty, and on the other hand the option to not ratify, not accept an instrument, which is also perfectly valid, then it doesn't make much sense to exclude all the in-between options. And reservations then become a way to maybe pull in or draw in reluctant states or states that are generally fine with the convention, a treaty, but really just had a problem with specific provisions. Now, Mégret in the chapter provides quite a comprehensive and I think also a very good discussion of how reservations operate in the human rights domain. And not be as comprehensive, but focus just on a few things that I think really are worth to be remembered. And again, our starting point here should be classical international, public international law, general international law, where basically reservations operate in the following manner. So let's assume there are three states, states A, B, and C, who have all agreed, ratified a certain convention, but state C actually provides a reservation to a particular provision. What we do then, in order to understand what legal effect these reservations have, is to break down the various bilateral relationships, so to say, between those two states. So state A and state B obviously don't have reservations, and so the full treaty is just in force between the two. Now things get more interesting, for example, between state A and state C. So state C the reserving state has provided a reservation, and state A is fine with that. So then what happens is that the treaty is applicable between state A and state C, except for that particular provision on which there's a reservation. Now state B, as opposed to state A, does not agree with the reservation provided by state C, which has the effect of basically making the treaty not be applicable between state B and state C. Now, that doesn't affect the relations between state A and state B and state A and state C, where these treaty obligations still are very much in force between those states. Now, as emphasized in the previous video, international human rights law is not essentially a reciprocal system. States agree to the obligations, but we really cannot rely on them, at least not very reliably, to enforce and to monitor whether other states are actually in line with the obligations. As a result, therefore, we are moving, and Mégret puts this, I think, very nicely, from a system in which reservations are either accepted or not, and this is how we know what legal effect they have, to a more axiological one, in which the question becomes whether a reservation is valid or not. And that obviously begs the next difficult question, which is, how do we exactly understand or determine whether a reservation is valid? And here, it's the jurisprudence, the case law of various international law bodies, including most notably Human Rights Committee, but also International Court of Justice and the European Court of Human Rights, which provide us some guidance. And in these various cases, or from these various cases, we can deduce sort of a bottom line, which is that a reservation needs to be in line with the objects and purpose of a treaty, of a human rights treaty, in order to be valid. This answers the question obviously only to some extent, but you can see here how there are at least some instances or some rights for which this is fairly obvious, and Mégret mentions the right to an effective remedy. So if you make a reservation to the right to an effective remedy, it's basically you as a state saying, well, I agree to this human rights obligation except for the fact that I will not give individuals the possibility to at all invoke them or claim them, which is nonsensical, defeats the object and purpose of a treaty. Another very famous example is the Louizidou case before the European Court of Human Rights, in which basically the claim was made by Turkey that Northern Cyprus, over which it effectively held control, Northern Cyprus would not be included in the jurisdiction that it holds in human rights terms. And again, the European Court of Human Rights rejected this argument, saying, well, this is your jurisdiction. You cannot simply pick and choose which parts over which you hold control, which part of your territory, essentially, you would like to have human rights obligations apply to. As you can see from this example, it's the European Court of Human Rights, so basically the international supervisory body of this specific treaty, the European Convention, that steps in to determine the validity of this reservation. And this is probably the last important takeaway here. In the context of human rights law, when it comes to reservations, but many other things, the authority that these international supervisory mechanisms yield is quite a broad and very important one, because without them, really, there would not be anyone to act as a check on whether states comply with their treaty obligations. This concludes the second video on reservations. I will now move on to other questions related to the centrality of the individual and most notably to the question of horizontal effect.